Rosenzweig. I have 10:30.
Okay, so do I. Thank you. It's a time, and I'd like to call this meeting of the Board on Electric Generation Siting and the Environment to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. We have Louis Alexander, alternative Basil Sagos, Department of Environmental Conservation in Albany. We've got Dr. Elizabeth Lewis-Michael, alternative Dr. Howard Zucker, Department of Health in Albany. We've got Vincent Ravashir, alternate for Eric Gertler, Commissioner, New York State Department of Economic Development and President and Chief Executive Officer of the Empire State Development Corporation here in New York. John Williams, alternative Richard Kaufman, New York State Energy Research and Development Authority in Albany. And myself, I'm John Rhodes, Chair of the Public Service Commission and Chair of this board in New York. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you. Well, let's get to business. Case 16F0205, application of Canasteo Wind Energy, LLC, for a Certificate of Environmental Compatibility and Public Need pursuant to Article 10 for construction of a wind energy project in Steuben County, presented by Maureen Leary, Administrative Law Judge, Department of Public Service. Richard Sherman, Administrative Law Judge, Department of Environmental Conservation. Dakin LaCates, Chief Administrative Law Judge, Department of Public Service. James McClymans, Chief Administrative Law Judge, Department of Environmental Conservation. And Robert Rosenthal, Counsel of Department of Public Service, are available to answer questions. Judge Leary, please begin.
Thank you, Chairman Rhodes. Good morning, and to Chairman Rhodes and members of the Siting Board. I was the presiding examiner in this proceeding by Canasteo Wind Energy for Certificate of Environmental Compatibility and Public Need pursuant to Article 10 of the Public Service Law. With me today to my right is Judge Richard Sherman from the Department of Environmental Conservation, who acted as the presiding examiner. Since the chair has already introduced Judge Leakakes, Judge McClymans, and General Counsel Rosenthal, I will not go any further other than to thank them and other members of the senior advisory staff for their extensive time and excellent efforts in bringing us here today to present this order. I will offer brief remarks in favor of the Siting Board's adoption of the proposed order, and I will also highlight some of its noteworthy aspects. The order before you consists of 4 parts. That is the certificate and order, and detailed certificate conditions which are appended to the order as Appendix A. Attached to those certificate conditions are 2 attachments, Attachments A and B. These include detailed information on required filings before the department, as well as a sound testing compliance protocol that the applicant is required to follow. The proposed order before you authorizes Canasteo Wind to construct and operate a commercial-scale electric generating wind facility in the towns of Cameron, Canasteo, Greenwood, Jasper, Troopsburg, and West Union, all located in Steuben County, New York. The order authorizes the construction of up to 117 wind turbines with a total maximum generating capability of 290.7 megawatts. The project also includes access roads, underground collection system lines, a collection system substation, permanent meteorological towers, an operations and maintenance building, a construction laydown yard, and a point of interconnection switch yard. In a separate but related proceeding pending before the Department under Public Service Law Article 7, Canasteo Wind seeks approval of a 15-mile, 115-kilovolt transmission line to connect the wind facility to the electric system grid via the New York State Electric and Gas Bennett substation, which is located in the town of Hornellsville, also in Steuben County. That proceeding is case number 19-T-0041. The Article 10 review process for this project was fair and open. It included extensive public participation, which I will outline. Public notice about the project was provided at significant milestones during the proceeding. Canasteo Wind's application, including amendments and other project information, was made widely available to the public First, through the Department of Public Services Document and Matter Management System, or DMM system, and through Canisteo Wind's project website. Canisteo Wind also provided hard copies of these materials to the towns in which the project is located and to local public libraries in the project area. The application and its amendments were served on the appropriate statutory parties and on other entities as required by Article 10 and the underlying regulations. There were numerous opportunities for public participation. For example, the department sponsored afternoon and evening public statement hearings in April of 2019. Immediately prior to these hearings, the department sponsored information sessions at which Canisteo Wind presented detailed information about the project and responded to extensive questions from the community. At the public statement hearings, several residents from the communities presented comments, which were transcribed and are a part of the record in this proceeding. In addition to comments presented at the public statement hearings, members of the public submitted approximately 235 comments to the department's DMM system, expressing both project support and opposition. Those who expressed support for the project cited the economic benefits to the local area, including temporary and permanent jobs, pilot payments to the towns, and the need in our state for clean, renewable energy. Those who expressed opposition to the project cited concerns about potential health impacts due to noise and shadow flicker from wind turbines. They also expressed issues with the project's visual impacts, economic impacts on tourism and local businesses, unwelcome changes to the rural community character, and other environmental impacts, particularly to wildlife. All of these public comments have been considered by the board and form a part of the record before the Siting Board today. For its part, Canisteo Wind undertook community outreach and public education efforts. The company established an office in the town of Canisteo, sponsored open house events, maintained a company website with information about the project, provided application materials to the towns and local libraries, as well as working with the local officials. Canisteo Wind also circulated to the public a toll-free telephone number and email addresses for questions and comments to be submitted by the public. After the project application was found compliant with Article 10's requirements, the examiners granted party status to the 6 towns in which the project will be located. We also granted party status to individual local resident John M. Sharkey and to a group of local residents known as Citizens for Maintaining Our Rural Environment. I will refer to them as Seymour. The examiners awarded pre-application and application phase intervenor funds that were provided by Canisteo Wind. Those were awarded to the 6 towns and to intervenor Sharkey. The towns and intervenor Sharkey and Seymour fully participated in this proceeding. They presented witness testimony and conducted cross-examination at the evidentiary hearing. They also filed post-hearing briefs and briefs on exceptions to the recommended decision. In short, both the towns and the intervenors clearly have contributed to the record in this proceeding. The order before you is based upon an extensive evidentiary record, which supports all of the required findings and conclusions the Siting Board must make under Public Service Law Section 168. Among other things, the record consists of Canisteo Wind's application and amendments, expert testimony, and exhibits. The record also includes the expert testimony, exhibits, and other submissions by the Department of Public Service staff, the Department of Environmental Conservation staff, and the Departments of Health and Agriculture and Markets. The 6 towns and intervenors, Sharkey and Seymour, also made such submissions. This record was compiled in large part during a 4-day evidentiary hearing held from August 19th to August 21st, 2019, in the town of Bath. Immediately following the hearing, on August 22nd, 2019, the examiners and the parties' representatives conducted numerous site visits throughout the 6 towns that comprise the project area. And it's important to note that those site visits took an entire day and covered an approximate mileage of, I think, 60 miles. In this, at least, Judge Sherman is suggesting. In the proposed order before you, the Siting Board is adopting a significant portion of the examiner's findings and recommendations set forth in their December 23rd, 2019 recommended decision. The 6 towns in which the project will be located are rural communities with largely agricultural land uses. There is a very significant Amish community located in the project area. Each of the towns has passed local wind laws, all of which include substantive provisions related to noise, shadow flicker, lighting, and setbacks, among other things. Notably, the order before you recognizes that Canisteo Wind has indicated on the record that the facility will comply with these substantive requirements established by each of the town's wind laws. Thus, the record fully supports the Siting Board's finding pursuant to Public Service Law Section 1683E that the facility is designed to operate in compliance with all applicable local laws and regulations. In addition, for the town's benefit, the order contains facility decommissioning, site restoration, and associated financial assurance requirements. These are intended to protect the towns from potentially having to bear the significant expenses at the end of the facility's useful life to perform decommissioning and site restoration. Of further note is the order's requirement that the facility utilize an aircraft detection lighting system, or ADLS, for the wind turbines, consistent with Federal Aviation Administration standards. With ADLS technology, the FAA-required aviation lights on the facility's turbines will remain dark or off until an aircraft is detected by radar. This available technological requirement will minimize the nighttime visual lighting impacts associated with the project. ADLS technology thus is consistent not only with the requirement in Public Service Law Section 168(3)(c) that the Siting Board find impacts to be minimized or avoided to the maximum extent practicable, but it is also consistent with the requirement in Public Service Law Section 1684A that the Board consider the state of available technology, such as ADLS. Notably, the Siting Board's order in Barren Winds similarly required utilization of ADLS technology on that facility's wind turbines. The proposed order here also contains noise and shadow flicker limitations that are similar or the same as those adopted by the Siting Board in previous Article 10 proceedings, approving wind facilities. These include Number 3 Wind, Bluestone Wind, and Barren Winds, among others. This order revises or modifies certain certificate conditions for purposes of clarity and consistency. It differs from the examiner's recommendations in certain limited respects. For example, the examiner's proposed adoption of a certificate condition that would require the addition of a 2 dBA or decibel uncertainty factor to the noise modeling to be performed prior to construction by Canisteo Wind. This order eliminates the 2 dBA uncertainty factor in an effort to assure that noise impacts are neither overestimated nor underestimated. The order also shortens to 60 days the time frame for the Siting Board's approval of the noise modeling so that construction is not unreasonably delayed. In this order, the Siting Board is clarifying as well that an applicant may identify a landowner as, quote, participating and therefore subject to different noise and shadow flicker limits only if that landowner has executed an agreement with the applicant. In other words, an applicant may not identify landowners as participating if they are still in negotiations or discussions about such an agreement with the applicant, which occurred here and resulted in substantial additional process in this proceeding. On the whole, the proposed order and certificate conditions address the identified impacts of the project. The order includes the required findings by the Board pursuant to Public Service Law Section 1683, namely, that the project as a renewable generation facility is a beneficial addition to or substitution for the existing electric generation capacity of the state, that the probable adverse environmental impacts of the construction and operation of the facility will be minimized or avoided to the maximum extent practicable, that the facility will serve the public interest, that the project does not have an adverse disproportionate impact on low-income or environmental justice communities, and that the facility's construction and operation will comply with all applicable state and local environmental and public health and safety laws. Significantly, the order also makes clear that the Siting Board has considered and found that the proposed wind facility as a renewable resource is consistent with the state's energy policies and long-range planning objectives and strategies contained in the most recent state energy plan. The order reflects that the Siting Board has considered the requisite factors set forth in Public Service Law Section 1684, including the project's potential impacts on community character, the electric system grid, and natural gas distribution lines, and that it has addressed other social, economic, visual, aesthetic, and environmental matters. We recommend the Siting Board's adoption of this certificate and order and the appended certificate conditions and attachments. This concludes my presentation. We are, of course, available for any questions the Chair and the members of the Siting Board may have. Thank you.
Thank you, Judge Leary. Thank you very much for this. This draft order, to me, results from careful and serious consideration of all the issues. I'm pleased by the open and extensively participatory nature of the process. I see that the environmental and health and community issues are all well developed in the record, that the consideration of these in the result has been balanced, and I like very much that the conditions for this wind project are aligned and compliant with the stated local needs. I also appreciate the useful and productive reliance on standards that have emerged over prior cases of wind farm siting. Obviously, I welcome the progress towards the compelling and necessary climate and energy goals here in New York State, and in some, I simply put, I find this in the public interest, and I will vote in favor. Mr. Alexander, any comments or questions?
Although I have no questions, just one general comment. I found that the order presents a very useful discussion on the two procedural matters. One, appropriate classification of landowners in terms of participating versus non-participating, and also the discussion regarding the entitlement. In this instance, relative to Seymour regarding access to confidential information. And I anticipate that the discussion here in this order will help serve in other proceedings as a direction and guidance as to the appropriate procedures to follow. Thank you.
Thank you. Dr. Lewis Michael.
No questions.
Thank you. Mr. Ravashir.
I have no questions.
Thank you. And Mr. Williams.
No questions.
Thank you. With that, I will proceed to call for a vote. My own vote is in favor of the recommendation to approve the application of Canasteo Wind Energy, LLC for a certificate of environmental compatibility and public need with conditions. To confirm the one commissioner order that was issued on September 19, 2019, and to deny the request for interlocutory review of the examiner's September 6 and September 9, 2019 rulings as described in the order. Mr. Alexander, how do you vote?
I vote in favor.
Dr. Lewis Michael, how do you vote?
In favor.
Mr. Ravashir, how do you vote?
In favor.
Mr. Williams, how do you vote?
In favor.
Thank you all. The matter is approved and the recommendation is adopted. Secretary Phillips, is there anything further to come before us today?
No, there is not.
Thank you. With that, I adjourn us. Thanks very much, and everybody.